SJC-12457, Commonwealth v. David T. Chalue.
Mr. Crouch, please.
Good morning, Your Honor. May it please the court, Andrew Crouch on behalf of David Chalue, who appeals from convictions out of the Berkshire County Superior Court. I'd like to begin today by addressing the first issue in the brief, namely that of the Tui Rodriguez errors in the trial court. Here we raise three particular errors. The first is that, as this court is well aware, a Tui Rodriguez instruction should only be given when there is clear evidence of a deadlock, and that did not occur here by all accounts. The trial judge said the jury was not deadlocked. The Commonwealth acknowledges the jury was not deadlocked. So we would suggest that that is one basis for error. And
Mr. Crouch, can I just ask you before you go forward, are you talking about the instructions that the judge gave to the individual juror, or are you talking about the instruction that was given to the full jury?
I'm talking about both in that circumstance, because I think it is an error to give both the individual instruction, which is, we would argue, is the second error, and then the full instruction is the third error. But just any connection of those two, none of them should have been given in this circumstance because there was no evidence of a deadlock.
But can we say that, I'm trying to figure out what made what the judge said to the individual juror a Tui Rodriguez instruction?
Sure. So moving to this, and that was all I had to say on the first.
I'm sorry, Katz, did we lose Justice Cipher?
We sure did.
Oh yeah, I think she probably thought it was the other case in which she's recused.
Let me.
Yeah, that's fine. That's fine. I don't think she's recused from this one.
She's not. He was on in a second. Let's just pause for a second and someone could text her.
I'll text her.
Thank you. She might have been disconnected.
Possibly.
Okay. She can't get back. So she's trying. Okay. Okay, she's trying a different computer now. She's trying to call in now.
Sorry about that.
No, thank you. We
Couldn't
have
connect
Justice.
anything.
All right, Justice Bud.
Should the timer be reset? I don't remember what it was on, but
Yeah, I think we put it back to 15, so I think we had stopped it.
is it supposed to be 20?
I think just Mr. Keneally stopped it when we interrupted.
No, I just mean, is it supposed to be 20 instead of 15?
It started at 20.
I'm sorry.
That's
This is
okay.
not- Time has just flown. Okay. Can I just go back to, you said there were 3 times when there was a mistake in Tui Rodriguez charge?
Sure. So to back up, the overarching issue was that the Tui Rodriguez charges, of which there were 2 Tui Rodriguez style charges that we allege were raised. We don't think either of them should have been brought in any circumstance because there was no deadlock. That's the full tilt of that argument. We then move to your question, Your Honor, with respect to the Tui Rodriguez style charge given to the lone juror.
Right.
And to address Your Honor's question, here what we have is, and we will agree, the Commonwealth suggests that this is not a Tui Rodriguez charge, and we would agree in the sense that it does not contain the full language of either Rodriguez A or Rodriguez B. And this court has said on many occasions that court should not freestyle the language. But here, what we have is we have the contours and the language of some of Rodriguez without any of the protections, without the guardrails. So here, when the judge talks to the individual juror, he does that in a way that he brings up, he uses the phrasing twice, keep an open mind and try to see if you can come to a unanimous decision. We would suggest that that language is very similar to the language, while not exactly in Tui Rodriguez, is very close to it and really gets to some of the problem parts. And what we cite a variety of cases from around the country in both federal and state districts that talk about the serious dangerous terrain that happens when a judge instructs an individual juror in circumstances where the judge knows that that juror is in a dissenting position, is in a minority position here.
Was there an objection here?
There was an objection. These errors are preserved.
And what was, and what should Mr. Crouch, what should the judge have done?
So here, what we suggest, and the objections could not have been more clear, raise the phrasing Tui Rodriguez, raise the issues. What the judge should have done here is more along the lines of, as I said, when courts know that there is a dissenting juror, they have to tread incredibly carefully. And they should not be talking about Tui Rodriguez or in the federal circuit, Allen, in any way. Here, when the juror, refused to go or was balking at going back into the jury room, which, as the judge notes, is not a particularly unusual circumstance. We cited all these federal and state cases. It's not unusual, not unheard of, not unprecedented. What the judge should have done in that circumstance is more along the lines of what happened in Torres, which is just simply inquiring as to whether or not that juror could continue fairly deliberating in the case without any mention of keeping an open mind, without any mention of trying to come to a unanimous decision. And that is the language what happened in Torres. It did not happen here. And it may have been the best intentions of the judge, but that's why these cases from around the country have made clear that when the judge knows who that dissenting juror is, you can't say things like this because the potential for coercion is just so substantial. And that is, essentially what happened here. The
Well,
judge,
two
Well,
things.
there's weird circumstances. Don't you think this, I'm sorry, just let me go ahead.
After you, please, Justice Link.
Oh, thank you very much. I was just going to say, it's really weird circumstances here. I don't know if I were a trial court judge taking a verdict and in the polling of the jury at the end of the trial, one of the jurors just says, well, no, I don't really think so. I don't know, what do you do with that? I mean, that's an unusual circumstance. That's a very unusual circumstance.
it's unusual, but again, not unprecedented. I cite,
The cases that you cite, are they, those are the, I haven't read your cases, but I mean, the cases that you cite are all in those circumstances that they're taking a
some of them
verdict?
are those circumstances, but we, at least in this Commonwealth, have had at least one, which is Torres, which is basically the same exact kind of circumstance where the juror says, no, I disagree. I'm not unanimous. And then, and so in that circumstance,
well, you understand why unanimity is on the judge's mind. You understand why that's on the judge's
I certainly do. In that circumstance, what might another better approach might be, to put the jury out, then bring them, talk to the attorneys, bring them back in, and just tell them all, hey, can you fairly deliberate? Get back, try it again. Just treat it like you normally would in the absence of a deadlock. We have plenty of case law, plenty of language and instructions for this type of circumstance, though unusual as it is, not unprecedented, not unheard of. And the judge himself seems to say, yeah, this can happen. And it doesn't seem fazed by it. The problem is that he treads over that line into very...
Well, that's the question. Is what was said perfect or close to perfect? No. But it doesn't have the most coercive aspect of Tui Rodriguez, which is don't hesitate to re-examine your opinion and change your mind if convinced it is erroneous. Be ready to change your mind if you feel the evidence requires it. It doesn't include that. And then what it does say a couple of times is, don't give up your beliefs. If doing so, and I can't remember the exact language, but don't give up your beliefs unless you're convinced otherwise. But Justice Link's point is well taken. This is a disaster of nobody's design. And she doesn't just say not guilty when polled. She said she won't go back into the jury room.
Yeah.
He's got to get her back in the jury room. And what he does is he tells her to keep an open mind twice and doesn't use the most coercive aspects of Tui Rodriguez. Look, this was not the right thing to do. It wasn't perfect, but it's not a judge like in Zabinski reading Tui Rodriguez to the juror before, patting her back into the jury room.
But instead, what we have here is the judge says these things, but also doesn't include any of the protective language that you hear in Tui Rodriguez and Allen, which tells her not only that she has to listen to her jurors with fellow jurors with an open mind, but they need to listen to her. Instead, we're missing that protective guardrail. And so this doesn't, if this was just once, perhaps I might be more inclined to that perspective. But this happens then twice when the judge then pulls the full jury in and again tells them with the open mind. And when we look at the case law suggests that we need to, that this court needs to look at this through the lens of that minority juror whose identity is now known. The judge knows it, the juror knows that the judge knows it, the fellow jurors know it. And so in that circumstance, I would suggest that the first instance of the instruction is sufficient error for reversal. But if nothing else, the second time when the juror is then told a part of a group who knows that this person is the minority juror that they are upset with because they've thrown down their pads of paper and their pens, they have mumbled and grumbled, there are people crying, they're upset. What happens then is she cannot help but feel picked out on, essentially, that, selected out as the person who's being told, keep an open mind for your fellow jurors, while they're not being told as the majority that they need to consider a minority opinion.
Weren't they told that the second time?
They were told the second time about the open mind. They were not told that the majority should consider them minority. If you're going to give the TUI charge, the reason that we don't allow judges to freestyle is because there are dangers here. And the protective language of TUI and Allen was not employed here. And that's a problem. So we would suggest that, these two points, when we look at the case law from around the country, we know that this is dangerous territory. The judge, tread into it in circumstances that were certainly understandable, but was told right away it was a TUI error, then repeated it the next day, and we would suggest that that is a basis for reversible error.
What did the counsel tell him? What did defense counsel tell him about it being a TUI error?
He literally said it was a TUI, you just gave a TUI Rodriguez charge. It was
And the
very,
judge said-
it
and
was
the judge said
very,
what?
very clear.
Yeah,
But-
that's not very helpful because it wasn't a Tui Rodriguez charge.
But
No,
it was, he basically said it was a TUI Rodriguez style charge, which our argument is that it was. It contained the language that, basically told an individual juror outside of the realm of the other jurors that that juror had to, consider their fellow jurors' opinions with an open mind in an attempt to come to a unanimous verdict, where the other jurors were not told that. And
Well, you're sort of skipping, keep an open mind, listen again. It's important that you not surrender your feelings if convinced. And then earlier on, he says, no one is suggesting that you surrender those feelings or your honestly held feelings about the facts of this case. Again, it's not how anyone would choreograph it with time to think it through.
I agree with that. And I certainly understand that there was some additional language couched onto it. But, I cite cases such as, I think it's State versus Gintner out of Utah that says in these circumstances, the inherent potential for coercion is so great that even mild protective language like that is insufficient to take this out of the realm of error.
Does he give the same instruction to the individual as he gives to the group? And does that mitigate concerns that he's pressuring the individual juror?
The language changes a little bit when he's talking to the full jury. And he's essentially, when he's talking about there, is he's again talking about, more about removing emotions and trying to reach a unanimous verdict. And then it says, please try to be patient and respectful of the views of your fellow jurors as you move towards that end. But, the cases that we cite tend to say, first of all, what makes this case unusual is this is given not once, but it's given twice. So even if it is not a full TUI charge, the minority juror has now been told twice to respect the views of the fellow jurors. And it is not made explicit, like in the TUI charge, that the majority must consider the views of the minority. And so that's where we think there is an error. I would like to, with the court's agreement, move to one other issue in the case, specifically the error that occurred with the allowance of substantial or relevant and prejudicial evidence. Specifically, I'd like to start with what this court will probably address as the Viovis evidence. And that is both the anatomical drawings and the evidence with regards to the photos of weapons. This court has twice addressed this issue in both the co-defendant's appeals and upheld the judge's decision to admit this evidence. Here, I would note that while these cases derive from the same set of facts, they were indeed tried separately, and the facts of this case, as brought out by the Commonwealth at trial, are meaningfully and substantially different from that was elicited in the co-defendant's cases. With regards to, and I can be fairly brief on this point, with regard to the photos of the weapons, this court found error in both the Viovis and Hall decisions with the court's admission of the evidence of the studded baseball bat. That evidence was admitted here, but unlike in the cases of Viovis and Hall, the forensic testimony here was not the same. Instead, what they said here was, there was no testimony as to the sickle. The testimony that the hatchets and the various knives could not have been used as implements either in the offense or in the dismemberment. So we would suggest that it's not just the bat, it goes beyond that. So I would urge the court to take a specific look at that testimony and how it compares to those other two cases. So I would suggest that the omissions of those items was error. But I think the more troubling situation is clearly with the admission of the anatomical drawings. And we reproduced these in our record appendix, and they are disturbing. We have illustrations.
Again, Mr. Crouch, you're too subtle right now. I don't get how this is any different than the two other cases where this issue has been decided against the co-defendant. So explain
Let me be
more
as
precisely why you say it's a different issue.
Let me be as explicit as I can. The evidence was different in this trial, meaningfully different than it was in the other two cases. In both the Hall and Viovis decisions, with regards to the anatomical drawings, this court said specifically the critical piece of evidence was that Hall said one of the guys really enjoyed torturing and cutting the victims up. That evidence does not appear in our transcripts. That evidence did not appear in this case. So this is meaningfully different.
Well, but there is evidence in this case that the victims were cut up and disposed of in bits and pieces, right?
It certainly was, but we don't just allow evidence that somebody had a passing interest in dismemberment just because, you know, part of the case related to that. Instead, it has to be much more specific. Otherwise, this is propensity evidence, it's character evidence. And so the problem here is this court was very clear that this critical piece of language that Hall said to another witness, you know, was the key linchpin reason, specifically said key linchpin reason that that evidence was admitted at that time, you know, was found to be admissible by this court. It does not exist here. So one of the three legs on which that evidence was admitted has fallen. And I would suggest the table falls with that lack of critical piece.
Well, if I could ask you, so Chief Justice Gans talks about that, I think, in context of state of mind. But
I don't think it was it was not state of mind. It was
to get to identity.
It had to do with identity, exactly.
I
right.
understand that, but that's how he gets to identity, is through state of mind.
Yes, through that. Well, he got to, I think that there were, in my reading of it, there were three independent bases for admission of that evidence. The first one was identity, and that was where there was some disagreement between the dissent and the majority with regards to that. But specifically, that was the critical piece of evidence, and it doesn't exist in this case. I see my time's about to expire. With the court's permission, I'd like to continue.
Please.
Okay. That critical piece, that critical leg is missing. Then we move to the issue of state of mind of Viovis. You know, this, you know, court, you know, in previous arguments has discussed, you know, some of these particular issues, but there is no, you know, Viovis's state of mind here. There isn't any connection to Chalue. There is no suggestion that Chalue had any idea, unlike Hall, that Viovis had this interest. You know, one of the reasons that this court talks, you know, affirmed it in the Hall case was because Hall is the one who made that statement, as Justice Lowy is noting. He said, you know, that, you know, one of the guys really enjoyed torturing, cutting the victims up, and that person was Viovis. Here, Chalue is not present during any of those statements. That evidence doesn't come in the trial here. There's no suggestion whatsoever that Chalue has any knowledge that Viovis has this interest. It's on the second floor of Viovis's house, a place where Chalue has only been to the house once. By all accounts, he doesn't go upstairs. The people who do go upstairs there say they didn't even see this evidence up on the wall. So there is no suggestion that he has any kind of shared state of mind or understanding that Viovis has an interest in this. And the third, so that leaves, I would suggest, only one remaining leg on which to admit this evidence. And as the court said, that the critical piece of evidence that allowed this evidence to be admitted was the Hall statement. I don't think it can stand in the absence of that. But with that respect to the last one, it is the motive for the killings to silence Glasser and the inexplicable nature of the crime. You know, I think from the reading of the case law and both Hall and Viovis's decisions, that is not a sufficient independent basis in the absence of the other two bases to allow this to continue to stand. As Justice Lowy said in his dissent, you know, there were additional reasons to, you know, while the Commonwealth is, you know, frequently says motive is not something they need to prove, and that's true. Here, there were sufficient other bases in the record to demonstrate, you know, why this case, you know, why the actions here were not inexplicable. Gruesome as they certainly were, you know, whether it's for transportation purposes, to hide evidence, or for, out of rage, because, you know, at this trial, you know, nearly 2 weeks of the evidence goes by without Chalue's name even being said, because it is just a recitation of all the grievances Hall has with Glasser and all of the myriad ways that he attempts to get back at him or stop him from testifying. Chalue is not involved in any of that. Instead, what happens here is, you know, the admission of this just purely on the basis of trying to explain to the jury why the dismemberment happened, I don't think is a sufficient reason to justify what is clearly prejudicial evidence. You know, as I said, we reproduce all that in the record appendix. It is very gruesome. It is disturbing stuff, and it has no connection to the defendant here. And accordingly, we would ask this court to reverse the defendant's convictions and ask that the court grant a new trial.
Thank you, Mr. Crouch. Mr. Capos.
Good morning, Your Honors. May it please the court. Berkshire Special Assistant District Attorney David Capus, appearing on behalf of the Commonwealth. I was lead trial counsel in this case. In addressing the matter of the colloquy, as I would describe it, with the sole juror, the circumstances here are very important. First, as defense counsel has pointed out, there's been no indication not only of any deadlock up to this point, but more importantly, no indication of any difficulty among the jurors or any particular juror. After the jury has been sent back out, when one juror, and it's important for the court to note that when the individual polling was done, this was the first juror who was asked. The judge properly stopped polling the jury at that point, so there wouldn't be any wading into discovering how the rest of the jury felt about it. So it's a presumption at this point to talk of this juror as a sole dissenting juror.
Can I ask you a point there, Mr. Capus? I thought that there was pretty much a general impression that all the other jurors were sort of throwing their things about in disgust with this juror.
At this point, no.
No?
There
When did that
was, you had some jurors that were, rolling their eyes, kind of thing, frustrating. They're being sent back out that already deliberated 3 full days. So that was somewhat normal. So they went out. But the judge is then informed that the A juror, because that's what the record reflects, A juror is refusing to go back into the courtroom. It does turn out that that juror number 1, but he's informed of this. He has to do something about this. The jury cannot resume and continue their deliberations until that juror is in the jury room. The judge wisely chose not to bring the juror back in and inquire what's the problem. Again, doesn't want to get into what's going on with the deliberative process or finding out where the jury stand. And so he speaks to the juror. As was pointed out, he doesn't simply say, listen to others. He makes the important statements to the jurors, and I'll quote, "If you have any honestly held feelings about the facts of this case, no one is suggesting that you surrender those feelings." And repeats it again at the end. And again, it's important that you not surrender your feelings if convinced. Both the beginning and the end of what the judge says to that juror is reassuring.
I'm sorry, Mr. Capos. Did Justice Link?
We've lost another.
I think she just got bounced out. What's
Was it something I said?
It's one of those days with the wind and the internet connections, I think.
Oh, wait.
Yeah. So, like,
Or try it again. Hold on for a sec. Come in. She's attempted to do so and is going to call in if it fails. So hold on.
Here I am.
Outstanding.
On a
We're
different,
back.
it's on a different, I have to use my iPad. I don't know what happened with the other one. I don't know. This court technology is really very, very surprising to me, always.
We have
I'll show you
everybody?
my picture. Yeah.
Okay, Ms. Capus, please.
To repeat, what's important here is that the trial judge, in addressing juror number 1, at the beginning and at the end, talks to her about her honestly held feelings and holding on to them. All of the cases that deal with the Tui Rodriguez situation and talk about his difficulties, Counsel brings up the concept of coercion. And I would suggest to this court that nothing of what Judge Kinder spoke to this juror about was in any way coercive. Didn't in any way say that a verdict was necessary, didn't single her out and talk to her in terms of her being a holdout or even a minority juror. None of that was there. On the contrary, I would suggest that what the judge said was reassuring to her. Because,
well, Mr. Capeless, if I could interrupt you for a moment. As I said, it was a tough situation and a difficult situation, to say the perfect thing, but you can't single out one juror at the sidebar and say, it's important that you listen to your fellow jurors with an open mind and see if you can come to a unanimous decision. That's just not the type of thing we want a judge telling a juror individually, never mind a clearly holdout juror.
well, but as I pointed out earlier, the context here is important. Judge Kinder did not decide, well, I'm going to bring this juror in and I'm going to talk to her. He was informed that she would not go into the jury room, so he had to deal with this situation. It wasn't a situation for him to speak to the entire jury. He wanted to see if there was a situation that he could resolve, and I think he did it in the most prudent way while avoiding pitfalls here. And as I would say,
it wasn't the most prudent way. He shouldn't have said to her, listen to your fellow jurors with an open mind, see if you can come to a unanimous decision when it's the one holdout juror. Again, I understand it's a very difficult situation. She won't go in the jury room. He has to talk to her. He has to find out if she's able to continue deliberating. He just can't take that aspect, and it's only one part of it, that aspect of Tui Rodriguez, and be telling the only holdout juror, don't see if you can reach a unanimous verdict, listen to your fellow jurors, because the only way to hear that is, come on, you've got to see if you can change your mind.
well, again, as I emphasized, though, he opens and closes by telling her, do not give up your consciously held opinions. And I want to emphasize that to you. That's what he says to her. And then
He surrounds that comment with, it's important that you not surrender your feelings if convinced. I understand that. And I understand that mitigates it. But he shouldn't have said that part of Tui Rodriguez. We have to at some point get to that was error to say that to the individual holdout juror. It's what to do with it. That's the issue.
Well, I think it can't be singled out that way because it's the whole context. And he didn't simply dismiss her after speaking to her. He asked her, can you do that? And she simply said yes. And then the juror goes out, the jury continues to deliberate for another 3 hours, and it's 6 o'clock. The judge asked them, what do you want to do? Do you want to continue deliberating or come back in the morning? And they say they want to come back in the morning. And that's what they do. Now, what happens is when they come back into the courtroom and the judge re-instructs them about, don't read anything about it and so forth, and sends them out. When they leave, a number of jurors express their frustration, facial expressions and the like, and at least one of them throws down, a juror notebook on the chair. And so after they're gone, a defense counsel requests that the judge deal with that situation. So in the morning, Judge Kinder does address them. He addresses them solely about the matter of emotions not having anything to do with their deliberations in their verdict. This is in no way a Tui Rodriguez charge. And in fact, it's important that he says, and he talks about, I urge you follow, when he refers to, as I've already instructed you, going back to his general instructions, that instruction, and remove emotion from your deliberations in an effort to reach a unanimous verdict if you can do so in good conscience. One of the problems that's been found with some of the Tui Rodriguez type of language is telling a jury you have to come to a verdict, that it's necessary. And here he's just saying how you can possibly come to a verdict if in good conscience you do it. And he was solely talking about emotion. I think this characterization of this as being a Tui Rodriguez charge is way out of line.
Mr. Caplis,
yes.
Mr. Crouch says there was an alternative the first time around, which was just to bring her in and say, can you deliberate, and send her back. What is your response to that? Less would have been more here.
It may have been a better way to do it. That's if she had said yes. What I'm pointing out is, having said to her twice, don't give up your convictions if they're firmly held and you believe in them, that he has reassured her. That is why she was able to say, yes, I can go back in.
Yeah, I'm just wondering if Judge Kinder's, he doesn't want her to talk, which we don't want her to reveal any of the deliberations. So he, in order to sort of short circuit any conversation, he doesn't sort of do that open-ended, can you deliberate question. Is that your sense? Is that why he didn't do the less approach? Because she would have to sort of respond.
Yes, I think so. And I think part of it was he wanted to reassure her that there was nothing wrong with her situation. She was acting as a juror should. This was her feeling, and she expressed it, and that she should go forward. And he did. To say, would it have been better just to say, can you go back in? If she said yes, but we don't know if that would have happened. She, having only asked that, she might have said, no, I can't. I'm not going to go back and face those people. She might not have felt the reassurance. Talking again, now moving to the question about the apartment of the co-defendant Veavis. Again, as has been pointed out, twice this court has rejected that argument. Admittedly, David Casey did not. He omitted to add to Adam Hall's statements to him about one of them really enjoyed getting into it. At the same time, we also have statements by this defendant, Chalue, to fellow inmates describing the gruesomeness that he participated in, particularly the idea of cutting them up and letting them sit for a while so that it wouldn't be so messy when they dealt with them later, to bag them up. So that you do have this connection to this obsession with the dismemberment. And I think that, again, it was just one prong, and it goes to Veavis's attraction, which is a peculiar attraction. It's not simply somebody who has a gun or likes guns in a case in which there was a shooting. This was quite peculiar, as this court has pointed out before. I think also that defense counsel mischaracterizes the expert testimony about the dismemberments, where the Commonwealth's expert said that not all of the dismemberments were exactly like as in those diagrams, but said that a number of them were very similar to them. So it was not a rejection of them, and said as to some of them, yes, they could not have been caused by hatchets, but overall, those were the type of implements that were utilized in this case.
Mr. Capeless, Chief Justice Gantz really stresses that one of the guys really enjoyed chopping the victim up was key identity evidence because of state of mind. And are we missing one of the stools of the chair in his analysis when we don't have Paul's statement, one of the guys really enjoyed chopping the victims up?
Well, as I said, that statement was not part of David Casey's testimony in this case.
That's my point. But that was an important aspect of the majority holding in Viola.
Right, but what I'm pointing out is that what was in this case that was not in the other two cases were statements by this defendant himself about the dismemberments and the gruesome aspect of it, and pointing about how the three of them had participated in it. And so that I think that, again, you don't have one aspect, you don't have what's in the other, but you do have something in a very similar vein that is present here that wasn't present in the other two cases. As to the—
Can you talk to the Aryan
yes,
Brotherhood?
just about to address that, Your Honor. First, the Commonwealth would state that the references to the Aryan Brotherhood was credibility evidence, not character evidence. First, there were only 3 witnesses of the Commonwealth who mentioned the Aryan Brotherhood, despite the fact that any number of the Commonwealth witnesses could have, because the defendant, David Chalue, made it very clear to anyone he came in contact with that he was a member of the Aryan Brotherhood. As for David Casey, he testified—
I'm sorry, Mr. Capeless. I think we have Justice Link gone again.
Okay.
Stop the timer. Here we go.
Justice Lincoln's back.
She is.
I am. I'm so
Okay.
sorry, Mr. Capos. I'm very sorry.
No need to apologize. As I said, this was credibility evidence. A major part of the defense in this case was the credibility of David Casey, Jethro Kempton, and Jeffrey Cashman. Casey had talked about Hall's statements to him admitting to the killing, and included Davey, who was identified as Chalue, and the other two were inmates who testified about statements describing how the kidnappings and murders had taken place to them. The defense was that these three were not credible, and absent their evidence, the Commonwealth had a weak circumstantial case. Much was made of their credibility on opening and in closing. I would point out that, in fact, in defense counsel's closing, he mentioned the Aryan Brotherhood 6 times. When in my closing, I mentioned it just once. For Casey, it was important because Hall had introduced the defendant Chalue as being a member of the Aryan Brotherhood. And when asked about why it was that he was not so forthcoming about talking about not only what everything Hall had told him, but particularly his own participation in the burial of the remains of the victims, that he said that he was afraid of retaliation by both the Hells Angels and the Aryan Brotherhood. So this was important testimony as far as context for his reluctance. As far as the other two inmates, their credibility was called into question, saying they just made this up. They got some idea about what he was charged with, and they told it. So the context of the Aryan Brotherhood, these other two being either Kempton, a member, and Cashman being a wannabe, of how it was they came to talk with the defendant. Secondly, the fact that as members or potential members, they would be people that he would trust enough to tell them about this. Why would he make these admissions?
Interrupt you again for a moment. So putting aside, this is not impeachment evidence, this is evidence that's bolstering. And you're supposed to, with limited exceptions, bolster after impeached. But put that aside because it's referenced in the opening statement, and that's perhaps understandable. But Cashman testifies to become a member of the Aryan Brotherhood, you're directed to do a hit, either to hurt somebody or kill somebody. That's not responding to a credibility issue.
All from current inmate.
Hold on, I'm sorry.
Still going?
Yes.
Please.
That relates to part of the circumstances later where Chalue finds out that Cashman has offered to cooperate with the Commonwealth. And he not only tells Kempton, but he writes out the note in which he says that he's now in the hat. And this was part of Cashman's explaining of what in the hat meant, so that it was going into part of the whole thing. And this was consciousness of guilt on the part of Chalue, saying this guy's a rat. He's now turned and telling what he knows about what I did and what I told him. So that is why that came in. It was in fact relevant to other testimony that occurred there. The judge took every precaution here to limit what had happened.
Well, he didn't take every precaution. In the United States versus Abel, which is a United States Supreme Court case, the Aryan Brotherhood language, which is critical to impeach defense witnesses, the way it's referred to in the trial court is a secret prison organization, and then they talk about their goals and their horrible goals. So he didn't take every precaution.
All right. Well, I think he took sufficient precautions to limit it. The potential jury pool was asked individually whether involvement with the Hells Angels or the Aryan Brotherhood could in any way affect them from reaching a proper verdict. And all of the jurors who were seated said that that would not. the judge had a pretrial hearing about what kind of testimony was being offered by the Commonwealth, and limited it strictly to these 3 witnesses, and that was related strictly to what was relevant to the testimony and how they came to give it. Each time that the Aryan Brotherhood was brought up during the testimony, the judge gave a limiting instruction, and then finally gave a further limiting instruction in the full general instructions at the end of the case. So I think that this was dealt properly. The question is, was this unduly prejudicial? And the Commonwealth's position is it was not. It was relevant to the case, and it was dealt with in, I would say, sufficiently limiting fashion that it did not cause undue prejudice to this defendant.
All right, can we go back to the illustrations, because it seems like for this defendant, it's fairly attenuated. You know, I get that for Viovis, you know, they were in his apartment. I get that for Hall, he's the one who made reference to Viovis wanting to, or being interested in cutting people up. But what's the connection between the illustrations and this defendant?
Well, again, there's no direct connection to Adam Hall, as there is with Chalue himself. The major part of this.
But I'm sorry, I'm looking at the, that I thought that one of the points was that Hall said that one of the guys really enjoyed torturing and cutting the victims up.
Yes.
I think we lost. I think we lost Justice Blank. I don't know if you wanted to finish this question, Justice Buddy, unless you want further inquiry. Justice Buddy, I'm sorry. Do you want further inquiry of Mr. Capewis, or you want to?
Yeah, I do. I want to hear this. I want to hear the answer.
So let's pause and await Justice Blank's return.
Sure.
She's trying to get back on.
Is there any possibility we could just shift her to a cell phone and have one of us call her and plug her in that way? Justice Gaziano?
Yeah, let me try to call her and.
Because I have a feeling she's going to keep going in and out if she's having this problem. Here she is again.
So sorry. I am here.
Okay.
I don't know what keeps happening. It just stops. I don't know what happens. I'm sorry. I'm very sorry to everybody.
And I think Justice Bud was asking,
Yeah,
Ms.
just
Capes a
about
question.
just what's the I get the connection between the Ovis and the anatomical drawings. I'm trying to understand the connection between those drawings and this defendant.
The drawings themselves don't have to have connection to this defendant, but they do have to have a connection to the commission of the crimes by the three of them together. And it's the same thing with Hall. As I pointed out to Justice Lloyd before when he asked the question, yes, that statement by Hall got omitted by Casey when he did it. But we have statements by Chalue that weren't in the other two cases that I would suggest replacing when he talked about the fact that they waited until the bodies had cooled and the blood had drained so that they could deal with them. Obviously, Mr. Chalue is not a pathologist, much less a doctor. And so the involvement of somebody who knew something about dismemberment was obviously a key issue here.
Thank you.
If
Any
there,
further questions of Mr. Capus?
No, thank you.
Thank you, counsel.
thank you, Your Honors.